All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Veuillez vous asseoir.
Good morning, everyone. I would like to welcome you in the courtroom. The Chamber is glad that we can welcome you in the courtroom, and not only virtually via some video links, except for the accused. I will come back to that. This indicates that we are going slowly but steadily back to normal. A contra indicia is this plexiglass in front of us, but I hope that in future status conferences or hearings, this will also vanish. Court officer, could you please call the case?
Thank you, Mr. President. The situation in the Central African Republic 2, in the case of the prosecutor versus Alfred Yekatom and Patrice Edouard Ngaissona. Case reference, ICC 0114-0118. For the record, we are in open session.
Thank you. I would like to ask for the appearances of the parties. We start with the prosecution. Please, Mr. van der Poeje.
Thank you very much. Good morning to you, Mr. President, Your Honors. Good to see everyone. Today, the Office of the Prosecutor is represented by Eric Iverson, seated behind me, and behind him, Yassine Mostafa. I'm Kweku van der Poeje. Good morning, everyone.
Thank you. And then Ms. Masida, please.
Good morning, Mr. President, Your Honors. For the victims of the other crimes, the team today is composed of myself, Paulina Masida, the other members of the team, Maître Abdou Dangabo Moussa, Maître Yaref Fall, and Maître Marie-Edith Douzima-Lawson are able to follow this hearing via the transcript live, and my colleague, she will introduce herself, is here with me.
Yes.
Thank you very much.
Yes, and she will do now, please. Microphone, please. It's not a problem. This in every case we had until now, there was this small problem.
Oui.
So we'll yeah, now.
Excusez-moi. Bonjour, Monsieur le Président. Bonjour, Messieurs les juges. Je m'appelle Elisabeth Rabessandratana et je suis représentant légal commun des victimes. J'exerce en France.
Thank you very much. And the next on my list, at least, is Mr. Knops for the defense of Mr. Ngaissona.
Good morning, Your Honors. I'm today assisted by Ms. Atuna Dijk, legal assistant, and Madame Sarah Pedroso, case manager, on behalf of the team of Mr. Ngaissona. Thank you.
Mr. Knops, I understand that Mr. Ngaissona has waived his right to be present via video link.
That's more complicated, Mr. President. I can, if the chamber invites me, explain the situation. But in our submission, he didn't waive his right to be present.
So how would you word it, but shortly, please?
Mr. Ngaissona is quite upset by the fact that already for 4 months he is kept incommunicado from his defense team, while on the 18th of June, a pedicure came to the detention center for treatment. Despite several requests, we were not given access to Mr. Ngaissona. He cannot understand why. I cannot explain to him why the measures, despite also the letter of the president of last Friday, which the chamber is aware of, where the president of the court insists that this is a really exceptional situation and that the defendant should have the right to prepare the case. All this accumulation is for him not acceptable. So he didn't waive his right. He principally says, I'm not accepting that I cannot be present in this courtroom. And to be honest...
I think that's enough, I think,
right.
on that. Thank you, Mr. Knops. So we take it that Mr. Ngaissona is represented by you, of course, today. And just one short remark from the side of the chamber. We all know that these are involving situations. We have taken note of your submissions about the situation in the Netherlands in detention centers. And you, as I'm sure, have noted a paragraph in our last decision where we invite the registry to also follow up on these matters and to think about loosening these restrictions. So I think this is a problem that will soon disappear, I would say. Thank you very much for the moment.
I would like to emphasize, Mr. President, it's not disrespect to the judges. It's for him the feeling that that his rights to be present have been violated, and he lost in this regard confidence in the system, and it will take some time for him to get confidence back in this trial. But this is what he also wished me to convey. I speak with him 7 days a week, every night, and I can acknowledge to the chamber that mentally for this person it's really difficult.
The chamber understands that the situation is exceptional, and this is, of course, heavy weighs on both accused. But as I said, we are sure that the situation will normalize. This is what I said in the beginning. And the chamber also takes it positively that you said that from Mr. Ngaissona's perspective, this is not conveying disrespect to the chamber. We take it as that, and I think we continue from there. Mr. Suprun, I think I have forgotten. Please, for the record.
Merci, Monsieur le Président. Bonjour, Monsieur le Président. Bonjour, Messieurs les juges. Les anciens enfants soldats sont représentés par moi-même, Dimitro Suprun, conseiller au bureau du Conseil public pour les victimes.
And now we're coming to the defense of Mr. Yekatom, please.
Good morning, Mr. President. Good morning, Your Honors. The defense of Mr. Yekatom this morning is represented by Mr. Florent Pages-Granier in the courtroom, Mr. Kairouz Abou Malhab as well in the courtroom. In the public gallery, we have Ms. Sabrine Bessa, Wilhelmina Whittingham, Jean-Michel Collat, and Daniela Mvungu Polis, and myself, Milen Dimitri. And although Mr. Yekatom would have wished to be present in the courtroom this morning, as you can see, he can appear via video feed.
Thank you very much, and we also welcome Mr. Yekatom from the video link. And then we have for the registry, please, finally.
Good morning, Mr. President, Your Honors. Today the registry is represented by Ms. Natasha Schauder, Senior Manager from the VWS, Ms. Soraya Brici, Legal Coordinator, VPRS, and myself, Pieter van Averbeke, Head of the Legal Aid Unit, Council Support Section.
And we should not leave this issue of appearances without introducing the judges of this chamber, because we meet for the first time. To my left, there is Judge Zhang Ho Chung. To my right, Judge Peter Kovac, and I'm Judge Bertram Schmidt. Today's status conference has been convened to set a date for trial in accordance with Rule 132, Paragraph 1 of the rules, and to discuss the preparation of the trial. We all know that this status conference ought to take place earlier. The chamber was also eager to hold the status conference on time, and it scheduled it for the 21st of April. But we also all know that because of the measures taken in light of the corona pandemic, it was not possible to have the hearing at that time. So we are in the situation that we are sitting here later than we would have hoped for as a chamber. For the information of the public, the chamber notes also that there are several medical restrictions that apply to today's status conference. In particular, the chamber notes that at least one accused, Mr. Yekatom, is following this hearing via video link from the detention center for their medical safety. For the same reason, the parties, participants, registry, and chambers staff appear only with limited teams to reduce these risks. Moreover, the hearing is currently limited in its duration. The status conference will be held in 2 sessions. I'm not sure if that will be enough, but let's see. from 10 to 11 and from 11:40 to 12:45. We have the option for another hour. That should not mean that we necessarily have to take it, but we have this option, so we have a little bit of leeway in that regard. The Chamber further notes that the status conference is held in open session unless a request to do otherwise is made by the parties, participants, or the registry. As I see it, most of the status conference can be held in public. Before getting into the details of the agenda items that you are aware of, the Chamber wishes to make some preliminary remarks. First, on cooperation. The parties and participants are expected to cooperate with each other wherever possible and to resolve matters inter partes before seizing the Chamber with a request. In the same vein, the Chamber expects that issues concerning matters within the registrar's purview be resolved directly with the registry and not first go to the Chamber. The Chamber considers this approach to be the most efficient. If a resolution has not been tried inter partes beforehand, the Chamber may dismiss the relief sought in limine. The Chamber also expects to receive submissions with a concrete relief. We don't wish to receive notifications which anticipate future requests that in the end may or may not come to fruition. The Chamber further expects the parties and participants to give due emphasis to the principle of publicity. In this regard, the Chamber recalls that the accused has a right to a public hearing, according to Article 67, paragraph 1 of the statute. That means, whenever confidential submissions are filed, the Chamber expects public redacted versions of these submissions to be filed as expeditiously as possible, preferably on the same day. The participants may reference the contents of confidential filings in public submissions, as long as these references do not reveal the information that gave rise to the confidential classification. Finally, the Chamber stresses that the classification ex parte should only be used in exceptional circumstances. Most importantly, it should not be used to gain a procedural advantage by excluding the other party. The Chamber recalls its instructions on communications with the Chamber sent per email on 26 March 2020. It expects the parties, participants, and registry to follow these instructions throughout the proceedings. The Chamber wishes for the communications with the Chamber to be as transparent as possible. It is therefore crucial that all parties and participants be copied in emails concerning requests to the Chamber, unless there is a good reason not to do so. In this regard, the Chamber also invites everyone again to make use of the existing email groups in order to avoid that relevant team members are omitted. In this context, the Chamber also recalls an email of 1st July 2020 that if a party or participant wishes to fully support a motion on the case record, it may do so by email if no substantively new submissions or new requests are made, and if all parties and participants who were privy to the initial motion are copied. In all other cases, the parties and participants are expected to file their views formally on the record. Finally, there is no need to copy the Chamber into inter partes communications. So these were the preliminary remarks. We are now going over to the agenda items. As requested by the Chamber, the parties, participants, and the registry have provided their submissions on several topics in advance of this status conference. These submissions have been very helpful to inform the Chamber of where things stand and to identify potential problems. We appreciate the efforts made by everyone in this regard. As indicated in the second scheduling order, the Chamber considers that it has received sufficient information on a number of items initially listed, which have therefore not been added to today's agenda. The Chamber will address these issues by way of written decisions. This includes, for example, the various protocols and the conducts of proceedings. The first issue that we want to discuss here is are the issues relevant to the commencement date of the trial. The Chamber notes that the submissions by the parties and participants and registry were filed on 8th April 2020. Since then, the circumstances and the measures imposed in response to the coronavirus pandemic have changed several times. I have already mentioned that. And frankly speaking, hopefully they will soon change again. The Chamber is therefore particularly interested in receiving updates from everyone on the impact on their trial preparation and the status quo, namely disclosure, ongoing investigations, protective measures for witnesses, preparation of a trial brief, and witness list. Before we start, I would like to ask you to be as concise as possible. We have, as I said, we have time, but not so much time. And please not to repeat submissions already made in writing. We are starting with the ongoing investigations, which is the first point we want to hear about. The prosecution indicated in its 9th April submissions, which are already 3 months away in the past, that investigations were still ongoing, but that due to the coronavirus pandemic, it cannot currently meaning at that time, provide a reliable estimation of an end date. Further, that it will update the Chamber by the month's end. So this would have been April, but so I think it was really time to do that. We would like, therefore, to give the floor to the prosecution to give us an update on the status of the investigations and anticipated end date of these investigations. Please, Mr. van der Poel.
Thank you, Mr. President. And I'll try to be as concise as possible in answering your question. The first thing is, where are we in respect of where we were when we made our previous submission? And the answer is essentially exactly where we were when we made our previous submission. As you might imagine, the impact on the potential to investigate or to continue to investigate matters which were already identified before the confirmation decision had been issued and thereafter have come to a complete standstill as a result of the COVID-19 pandemic. The prosecution has not been able to travel effectively, has not been able to implement measures with respect to witness protection issues as efficiently as it would otherwise be able to do. And so it effectively ground the investigation to a halt. There are, as you properly noted, some improvements in the situation, at least in Europe, in terms of the ability or the mobility of the investigation. And to that extent, we are making inroads, but that's only just begun with the lifting of restrictions in certain EU countries. But beyond Europe, the investigation is effectively stopped. It's not possible to travel to CAR. I'm sure it's not too much different for the defense as well, in order to conduct operations on the ground there with respect to the collection of documentary evidence, which needs to be completed, as well as to interview or re-interview certain witnesses that we've already identified to call in the case. So that's basically it in a nutshell. In terms of what we've been trying to do, I can tell you that the office has been trying to put together a protocol to conduct remote interviews, and it has been applied in some cases with success. It is a bit more difficult to apply that in the Central African Republic because the infrastructure is not as conducive to being able to carry out those types of activities.
Thank you. And I spoke already about the hopefully evolving situation here at the court and in the host state. What are the prospects? Of course, you can't look into the future exactly, but is there some hope for a change of situation?
From our information so far, the number of COVID cases is on the rise in the Central African Republic. I think they've cleared now 4,000 infections, and I can't remember how many deaths, but there have been a number, I say 40 or 50 deaths as a result of that. Our understanding is that that is not expected to peak until October or September coming. The restrictions that remain in place, the restrictions rather that were imposed earlier on in the pandemic largely remain in place. People can circulate with masks and social distancing and those kinds of measures that have been applied here, but you can imagine how difficult that would be to control in an area which has a limited infrastructure, limited enforcement capacity, and it also would affect staff resources from the court that are assigned to those locations, and we have to look out for their health as well. So it's hard to say when it's likely to improve, but our understanding is that things are getting worse and not better, up at least until September or October when the peak is expected.
Thank you. This is duly noted. Does the defense want shortly, if you want, shortly to comment on that? You need not, you don't have to, let me put it this way, but if you want, you have the floor. Mr. Knups.
Thank you, Mr. President. Mr. President, when we're speaking about preparing the trial, it should be noted that the prosecution, in its investigations, already received from the pre-trial chamber, as the court noted, twice extension of time. Secondly, it admitted that it was surprised by the unexpected speed of the arrest of the two accused persons. We all know, based on the jurisprudence of this court, that the investigation, I refer to paragraph 119 in the Kenyatta decision of 2013, that it's obligation of the prosecutor to have completed its investigation prior to the confirmation of charges hearing. We all know that there are exceptions, but these exceptions are really strictly circumscribed in the jurisprudence. The pandemic, in other words, can, in our submission, not be an excuse, although we fully understand that we're all dealing with this, even defense, cannot be excuse to push back the trial date. Our submission is that the chamber should no longer fix a trial date depending on the apparent ongoing investigations, but should fix the date as soon as possible, perhaps even by the end of this year. This is the position of our team, our client, who is already for almost 2 years, Mr. President, in pre-trial detention under harsh conditions, as the chamber is really aware of. And with due respect for the circumstances in the world, it cannot be an excuse to prolong a trial date. The prosecution had its chance to conclude the investigation prior to the confirmation of charges in accordance with the Kenyatta jurisprudence. Thank you.
Do you want to add something, Ms. Dmitri?
Thank you, Mr. President. Just one point. The remaining of my submissions are more related to disclosure, which is, I think, another point on your agenda. My only point, Mr. President, is, as my learned friend indicated, investigations should have been largely completed at the stage of confirmation hearing. Mr. Yekatom has been in detention for almost 2 years, so we have to take that into account. Even by April, when at the time the prosecution made their submissions, investigations should have been largely completed so we can move on with this case. Thank you, Mr. President.
Thank you. The chamber is aware of and recalls the appeals chamber jurisprudence that indeed investigations should largely be completed at the stage of the confirmation of charges hearing, and the chamber agrees with that view. The chamber also recalls pre-trial chamber 2's findings in this regard in the present case. And while the chamber will therefore take the prosecution submissions into consideration, it likes to stress that the ongoing investigations will not be the determinative factor in setting disclosure deadlines and a date to commence the trial. You have already flagged this, Dimitri. The disclosure is the next point, and a very big point, I think. And we will be starting with the ongoing disclosure obligations, in particular timing and volume of outstanding disclosure. The Chamber will set a final disclosure deadline in due course. In the meantime, the Chamber recalls the prosecution's, and you know that, of course, Mr. van der Pooijen, rolling disclosure obligations, and emphasizes that disclosure must be effected as soon as possible. Furthermore, and again I come back to that what I mentioned at the beginning, the Chamber stresses that it expects the parties to resolve disclosure issues inter partes whenever possible. Of course, you might go to the Chamber if there is disagreement, but the parties should really strive to resolve these issues inter partes. In its submission 474, the prosecution indicated that it has disclosed 86% of the evidence, that it originally, that means before the coronavirus pandemic, anticipated finishing its disclosure by mid-fall. The Chamber considers, of course, with this information in mind, that would be assisted by receiving an update on both the status quo of disclosure as well as the anticipated date of full disclosure. I give again Mr. van der Pooijen the floor.
Thank you, Mr. President. If I could just return to the previous issue for just a second, if that's all right.
That's fine.
Thank you.
It seems to be related, so why should I deny it?
Thank you. That's very much appreciated. With respect to the ongoing investigation, I just wanted to point out a couple of things. First of all, I agree completely with the Chamber, the team agrees completely with the Chamber, that that is not a dispositive issue with respect to the setting of a trial date. But we feel it's important to bring the circumstances to the attention of the Chamber, so the Chamber is perfectly clear and we're transparent about where we are, where we want to be, where we expect it to be, but what the impediments are and what we're trying to do to resolve them. So that's the first thing. The second thing is, as the Chamber is aware, and I think the defense is aware, pretty much everyone is aware, that the investigation in this situation involves a parallel investigation. And to the extent that there is a parallel investigation into Celica crimes, there is obviously the possibility that information that is received in relation to that investigation will have an impact on this case. Because we have warring parties, we have an armed conflict which involves the two groups. Clearly an investigation into one.
It might very well be exonerating.
It could be exonerating
evidence,
and it could be incriminating, but the point is that it's ongoing. And that is a part of the investigative activities that are related to this case, even if it's not about this case. The second thing is, with respect to the investigation, my understanding actually of the Appeals Chamber's jurisprudence is that it is the exceptional circumstance where a chamber should intercede to stop an investigation, not the other way around. And I think Mr. Knops has got that a bit backwards. It is the exceptional circumstances which authorizes the Chamber to stop an investigation, not the other way around. And I think that's quite clear in our jurisprudence. The third thing is, in respect of the investigation of these specific accused, it's important to bear in mind that they are charged, obviously, with individual criminal responsibility for the charges that were confirmed. But those charges were confirmed in the context of group crimes. And so the investigation as respect to members of that group should not be stopped by virtue of the fact that there is a trial against the two members of that group. Because our obligation under the statute, pursuant to Article 54 and in accordance with the mandate of the Chamber, of the court, is to investigate those individuals who are most responsible for the crimes within the context or the framework of the situation in this case. These are but two of them. And we have said repeatedly, and in the confirmation process itself, that there are many individuals who are responsible for the crimes that occurred in this, that are the subject matter of this case, and that are the subject matter of other matters that we are investigating. So that I just wanted to lay out so the Chamber is aware of what we're talking about when we're talking about ongoing investigations. And the last point is that we are following up on investigations that were begun long before the confirmation decision was issued, because that is the nature of that is the manner in which cooperation efforts proceed. You would be aware of the motion that we filed to amend the charges with respect to both of these individuals, and you will be aware that the efforts to investigate the crimes which were the subject of those amendment applications began in April, May, and June of last year. And it was only recently that that investigation was actually able to come to fruition because of the nature of cooperation efforts. And that's the reason why I wanted to lay that out.
But please now to the actual status or quo of disclosure.
Yes, I'm sorry about that. I just thought I had to make the
Mr. Knopf, please let Mr. Van der Poel talk now.
With respect to the state of disclosure, Mr. President, the first thing is, I believe in our prior submission, we had indicated that we had reviewed about 86% of the collection. Obviously, the collection is a moving target because of the nature of collateral investigations or related investigations. It's one pool of information. So to the extent that information is gathered in respect of a different investigation, it still falls into the pool to be reviewed in this case. That said, we indicated back then that we had about 10,000 items that needed to still be assessed. And what I can tell you is that we are down now to about 2,500 items that still need to be assessed. And by assessment, what that means is, first of all, identifying basically what box this material goes into. There are different phases of review, as you can imagine. The first is when you have a bunch of information, well, what are they? Are they bills? Are they letters? Are they magazines? This basic sort of assessment still has to be done with respect to 2,500 documents. Once that is done, and we expect that we are on target to meet the disclosure deadline that we indicated previously, but we still have overall number of documents to assess of about 23,000. And that's quite a lot of material to get through between now and mid-fall. So that's basically where we are, and we still think we're on target. We have galvanized other resources from other teams in order to help our team get through this volume of information in that amount of time. So I think we indicated before mid-fall, and I think that's probably right. My estimation would be probably mid to end of November.
Thank you. We will come to the specifics soon. Just one short remark, perhaps, which would make Mr. Knopf's intervention obsolete. I don't know. Of course, we understand that there are ongoing investigations, that there is another, now in brackets, another party also there that they are are investigating. But that at some point in time has to be separated from the question if evidence that evolves from such investigations can be used against these accused here. So that's a different point. We have that's not the same. Mr. Knopf, did you want to comment shortly on that?
Yes, if I may, Mr. President. Yes, sir. Thank you. Mr. President Jonas, we are now 9 months after the confirmation of charges hearing. The prosecution still says it needs time because there is a parallel investigation into the Celica. In the case which was before this chamber a few years ago, there was a similar situation, the case of Côte d'Ivoire. The former president of Côte d'Ivoire, Mr. Gbagbo, and one of his former ministers, Charles Blé were tried before this court, and there was a parallel investigation into the supporters, alleged supporters of the other presidential candidate who was ultimately elected. That didn't prevent the chamber to commence the trial, not at all. If during that investigation into the Seleka formations, exculpatory evidence arises, no problem. It can be submitted every time. But that does not prevent us from starting this case. It cannot be so that the prosecution, 9 months after the confirmation charges, still gets time because it conducts a parallel investigation. It's about the charges which were confirmed by the pre-trial chamber. And Mr. President brings me to a second point. The jurisprudence of Kenyatta is not the reverse situation as suggested by the OTP. If you read paragraph 121 of the decision of 2013, it's clearly that the chamber said, the majority of the appeal chamber, the prosecution has the obligation to finish his investigation before the confirmation, but only in an exceptional situation. If it can prove that that evidence was not reasonably obtained with due diligence before the confirmation, that's different. So the citation we gave is not a reverse situation. And finally, Mr. President, the amendment of the charges, that doesn't justify either an ongoing history. The pre-trial chamber denied in firm words the suggested amendment. That means the investigation, the prosecution is asking for this, can immediately be stopped because there is no amendment of the charges. And finally, Mr. President, the disclosures. We asked the chamber, and I believe you, Mr. President, you just suggested it yourself on behalf of the judges, that we suggest the chamber to set indeed a calendar for disclosure.
We are coming to that.
Yeah,
So
okay.
you can defer that. I think it might not be necessary then to come back to it. Thank you very much for these submissions. You can be sure that the chamber is aware of the appeals chamber's jurisprudence in that regard and also aware of how to interpret it. We are coming now to the disclosure of witness identities, more specifically, that are or have been withheld from the defense and with to the correlating issue of protective measures. There are, as it seems, different areas that we would have to want to receive information. As regards witness identities, the Chamber notes that according to a prosecution filing 474, only one incriminating witness identity has been withheld, and disclosure is expected in the near future. Second area is the prosecution indicated that it does not intend to call at trial car witnesses whose identities the PTC authorized to redact, and expects these redactions to remain as long as necessary to protect the Seleka investigation. Here's again the Seleka investigation comes into perspective. Thirdly, according to the prosecution's more recent filing 553, the individual risk assessments for a handful of witnesses, as it is worded, on the preliminary witness list are pending, and disclosure has thus not yet been effected. Furthermore, this process is expected to be completed before the judicial summer recess. The Chamber notes that this list includes 11 witnesses whose identities are redacted and are unknown to the defense at this point. And 11 is already a bit more than a handful. The Chamber also notes the prosecution submissions with regard to pending and anticipated requests for protective measures. Again, noting the elapsed time since the submissions to the status conference were filed, the Chamber would like to hear from Mr. van der Puye about how many identities are in fact, first, how many identities are in fact unknown to the defense at this point, first. Second, the status of pending individual risk assessments, as well as anticipated requests for protective measures, and related to that, when witness identities can be disclosed to the defense. And thirdly, the relevance and impact of the Seleka investigation to disclosure in the present proceedings. You have touched already this point, so you can mainly speak to us to the first 2 points. How many identities unknown and status of pending individual risk assessment? Please, Mr. van der Poel.
Thank you, Mr. President. All right. With respect to the number of witnesses that remain to be disclosed to the defense, I think we're now down to 6, which I think is not too bad. 2 have been referred to the VWS, and so they are processing those referrals. There is one additional one for which the finalization of security assessments and the implementation of the appropriate measures that will be in a position to disclose this person, but it will depend on how the pandemic, the course of the pandemic in the CAR. 2 witnesses are not reachable. And then there is one other witness, the circumstances of which I would have to discuss with the Chamber on an ex parte basis. So that's the status of the 6. I think, and I should commend our Protection Strategies Unit, which has done really an exemplary job in organizing and making sure that our witnesses are protected. As the Chamber is aware, we have preliminarily identified 152 witnesses, plus some experts that we will call. So I think, relatively speaking, we're in good shape.
Thank you. We would like to have information, if you have it, from the VWU in that regard, if you can give us an update. Ms. Schauder, please.
Thank you, Mr. President. Indeed, the VWS is still in the process of assessing or finalizing the assessment of 3 witnesses. Most of the witnesses that has been referred were dealt with much in advance. So at the moment, we are down to 3 assessments to be conducted and measures to be implemented.
And do you have any?
I'm sorry.
Do you have any idea when this process will be completed?
As mentioned already by our colleague from the prosecution, we are very much in the hand of the possibility, or the reduced possibility that we have to operate in the Central African Republic. And social distancing and the measures that are preventing us to meet with witnesses in order to assess them, then to implement measures. We are making plans at the moment, together as well with the medical officer of the court, to see what would be possible in that respect.
Thank you. Any submissions by the defense? Yeah, please, Ms. Dimitri.
If I may, Mr. President, thank you. I apologize, I think I'm a bit lost with the numbers. According to my assessment, 11 witnesses were unknown by the defense, were redacted. One of them, P1792, we now know his identity. We only have a summary. We're still waiting to receive his statement. And according to, again, if my memory serves me right, P1442, yes. P1442, who was initially redacted and unknown to the defense, has been cleared and disclosed, which brings the number, according to my count, to 9. There's still 9 remaining witnesses whose identities are unknown from the defense.
9 seems to be 3 more than 6. So perhaps this discrepancy can be solved by Mr. van der Poel, or perhaps not, I don't know.
I would err on the side of not, at least not on my feet. I'll look into it, and we can solve this, I think. I should add that there are some matters of disclosure that are in the pipeline, and so it may very well be that the numbers are right, but the matter is actually in the course of being disclosed, or that information is being shared. We have a couple of disclosure packages that were slated to go out yesterday, I think, or the day before. So in that respect, there was a technical problem and it didn't go out. So it may very well be that this information is on its way. I'll discuss it with counsel and get back to the court if you would prefer.
Thank you. I think that should do for this item. The next item, and I think this is the last one that we can discuss before the break, is the trial brief. The Chamber considers a trial brief to be a useful tool for the preparation of the trial to everybody, all parties, participants, and of course also the Chamber. The Chamber equally considers a provisional list of witnesses, a list of evidence and summaries of the anticipated evidence testimony of the witnesses to be useful. As regards the provisional witness list, the Chamber recalls that the prosecution has already filed a preliminary witness list on 15th June 2020. We will discuss this later on in more detail. This list, which is a novelty at the court, has been ordered by the Chamber in light of the specific circumstances under the coronavirus pandemic. The list was considered necessary in the present circumstances to ensure the accused's right to a fair and expeditious trial, and to have adequate time to prepare their defense, as well as to mitigate the delays that unfortunately have been caused by the coronavirus pandemic. Now that the case is moving forward, the Chamber considers that in line with the practice of the court, a provisional, not preliminary, provisional witness list should be provided. Only minor changes will be possible to this list. Major changes should be limited to instances where a concrete justification exists. In terms of timeline, the Chamber notes the prosecution's submission that it is prepared to submit a trial brief 30 days before the start of the trial. We would like to hear from the prosecution again first by what time it would be able to provide the already mentioned provisional witness list, a list of evidence, and summaries of the anticipated testimony of the witnesses. Yeah, you know, Mr. Van der Pooijen, you are really on the spot today, so, but because it largely depends on what you are saying and how we assess this, so to speak, how the case is going forward. So please, you have the floor again.
Thank you very much, Mr. President. Indeed, we did indicate that we would prefer to file a pretrial brief some 30 days before the start of trial. And you're right, it is a novelty to have provided a preliminary witness list. It's the first time I think it's been done, and I think it was a good idea. It does enable the defense to get their head around what the scope of the case is and where we're going in terms of the evidence that we intend to produce. The question of a provisional list is a different one, though. Normatively, that would accompany the list of evidence, and in our view, that should follow the disclosure or the completion of disclosure in the case, which I indicated already was what we're looking at in terms of timelines is mid-fall. So what I would propose is, and I think it is quite the norm at the court, is to provide the provisional witness list and the list of evidence 90 days before the start of trial, the pretrial brief 30 days before the start of trial, together with the witness summaries. So it would be list of evidence 90 days before, witness list 90 days before, witness summaries 30 days before, and the pretrial brief 30 days before. With respect to the 30 days before, what I mean there is at the latest 30 days before. So our objective would be try to provide it sooner, but I think that the workload that is going to go into preparing a case as large as this one, I would prefer to have the deadline staggered, which I think would be more conducive to an efficient presentation of the case. That's the idea. I hope I've answered your question. I tend to.
No, you have. You were very specific, I would say. Even. There might be the urge, so to speak, by defense counsel to comment on that, but if not, of course, we would also accept it. Then first, whoever wants to speak first, please confer with yourself.
you, Mr. President. I might be long on this point because it spills over with disclosure, remaining disclosure. So I'm in your hands. I can address this after the break. Or maybe Mr. Knoeps can speak first and I can go ahead after the break.
We can continue a little bit further than 11 o'clock. So the maximum, as I have been informed, 10 minutes. So we would have the maximum until 10 past 11. So I think we can have both your submissions during that time period. Please start. So, and you know, of course, you have to leave Mr. Knoeps a couple of minutes.
Thank you, Mr. President. Also, our defense team believes that this topic, the providence of a provisional witness list, comes closely with the disclosure obligations. I will be brief, and Ms. Dimitri can address it after the break in more extensive manner. In light of the disclosure conduct of the prosecution in the past, and I don't have to remind the Chamber to your ruling of the 15th June of this year with respect to a specific witness, paragraph 31 and 29. This was Your Honor himself who ruled in this matter. And also the findings of the pre-trial chamber. I have the dates here, 3 September 2019 and 11th December 2019, where the pre-trial chamber 2 concluded that the prosecution failed to fully discharge its obligation to disclose exculpatory information. We submit that the chamber should fix a clear deadline for all disclosure obligations of the prosecution and not leave this anymore in the hands of the prosecution. It suggested that it should have the discretionary power in good faith to disclose, but unfortunately the history of this case has provided us with contraindications to this. So our primary request to the chamber is to set a deadline for all disclosures which are imminent for the trial. That's first. Secondly, the providence of a provisional witness list. It was Your Honor yourself who decided, and I have the reference here.
Please simply cite it if you want to, so we know what we
Yeah,
have
it was the order to provide the preliminary witness list of 22nd of May, paragraph 5, where the chamber ruled that disclosure of evidence related to witness listed on the preliminary witness list must be effected immediately. So there is already a ruling of the chamber to this effect. And we emphasize that in light of this existing order, the providence of this preliminary witness list should be effected immediately. Secondly, with respect to the trial brief, in line with practice before this court, providence of a trial brief 30 days in advance of trial is not the common term and not the common time frame for disclosure of the trial brief. There is no jurisprudence the prosecution relies on to say that in this situation the providers of a trial brief the term to provide it should be shortened to 30 days. In our submission, that's really too short before the trial. Secondly, the pre-trial chamber considerably reduced the scope of the charges. We will speak about this, I guess, after the break. The prosecution didn't seek leave to appeal that decision of the pre-trial chamber. And it's our submission that in light of the significantly reduced scope of the charges in the case of Mr. Provisional and Ngaissona, that a trial brief should also reflect this scope, and therefore a time frame of 90 days before trial of a trial brief is quite reasonable. Thank you.
Thank you. Ms. Dimitri, if you can make it in 10 minutes, I would give you the floor, and I think that should be possible.
Thank you, Mr. President. Indeed, I can. So I would like to support Mr. Knoop's observations and submissions. We would like the Chamber to order a disclosure deadline. Indeed, in your 22nd of May decision, the Chamber stressed that the disclosure of evidence related to the witnesses listed on the preliminary witness list must according to the prosecution's preliminary list. Some of them, as I said earlier, are already in the process of being cleared, and we heard submissions earlier on that. So those who have been cleared in the meantime, their statements should also be disclosed immediately, as set out by your honors in the order. So this means that the prosecution can make efforts clearing the remaining witnesses appearing on their list, and fulfill their disclosure obligation immediately in relation to the witnesses who were cleared and who are appearing on the preliminary witness list. So for those reasons, we're asking the Chamber, in order for the defense to meaningfully prepare, to order now a disclosure deadline earlier than November. And we are also asking your honors to have a strict deadline for the prosecution to comply with in relation to evidence related to the witnesses appearing on the preliminary list of witnesses.
Mr. President, may I just add 1 second? This argument is very important.
Very shortly, please.
Yeah, one second. Maybe the court is not aware, but your order of, Your Honors, your order to 15 June, in this specific instance, I will not mention the P number, but Your Honors know which decision I refer to, the disclosure of a certain witness, which credibility was at stake. Last Friday, the defense received the disclosure package pertaining to your order of 15 June, and these discussions about this disclosure were initiated in August 2019. It's from the history of the case, and you find it in the decision. So it took the prosecution 11 months to provide the material which was already acknowledged by the pre-trial chamber. Therefore, this is an additional argument to say to the court, please set a firm disclosure deadline. Thank you.
Okay. Thank you very much. So I really, when I hear that, your submissions, I want to recall what the chamber said initially at the beginning of this status conference, that nevertheless, what has been in the past, the chamber expects in principle that also disclosure issues have to be resolved inter partes first. That at least there has to be tried to resolve this inter partes. And the chamber expect efforts from all parties and also participants in that regard. Nevertheless, the chamber will issue, of course, a decision on the schedule leading up to the trial in due course, which will set the commencement date of trial, as well as deadlines for disclosure, the provision of a trial brief, and other documents. I think we have now overstepped only a couple of minutes. I have been told that the break has to be 45 minutes, so we reconvene at 10 to 12.
All rise, veuillez vous lever.